Greetings, folks. My name is Eric Sinrod. I'm with the international law firm of Duane Morris. I'm based in San Francisco. This is your weekly Tech Law 10, where everything law and technology intersects. Of course, as always, I'm joined by my partner, not in crime, Jonathan Armstrong, across the pond in England. And Jonathan, of course, you'll introduce yourself, but I have this idea, I have this mind meld going on that you're thinking about social media, potential liability, and related issues. Am I right?
Yeah, you are indeed, Eric, and thanks very much for joining me. As Eric said, I'm Jonathan Armstrong at Hunter Southall Law. I suppose what's prompted it with me is the role of social media in the recent riots in the UK. And clearly, there are some who say that the promotion of conspiracy theories and errors exacerbated the riots. And indeed, many courts and judges think the same. There were about 4,000 people arrested to date for their part in the riots. I can't give you a breakdown of how many were social media crimes and how many weren't, but I can tell you that of those 4,000 arrested, within 2 months, we'd had 1,984 prosecuted. Now, many of those who've been sentenced already have pleaded guilty, but social media hasn't played a trivial role in this. Jordan Parler, for example, one of those convicted, has 20 months in prison for his use of social media to exacerbate the situation. And what that's led to, I think, is to people to look at not only the role of individuals, but also the role of social media platforms. Now, first of all, of course, I did a short program on the BBC on the right to speech. And whenever people have somebody knock on their door, they say, oh, we've got a right to free speech. And they usually, weirdly, sort of claim that they've got rights under either the Magna Carta or sometimes under the US Constitution. And I think that's what you get when you study law via TikTok. And there's clearly a lot of people who've got the wrong understanding. And of course, we've never had the right to say whatever we wanted to anybody. We've never had the right to shout, kill him down the street and ask a baying mob to chase somebody, which is more or less what happened here. But if we go back to sort of Roman times and kill him, I think there's another analogy that we might use as well. Now, I studied legal history at university, but this is a recollection rather than something entirely accurate. But I think that the law on things like mere conduit, so the law that protects platform operators from primary liability, I think stretches back from memory to Roman times, where there used to be laws over the running of marketplaces. So to take you back in time, Eric, imagine that I've got a market stall in the Roman Forum, and I don't know, Septimus Maximus, the purveyor of asses' milk. And you come to me and I say, it's Mr. Sinrod, Senator Sinrod, it's the most divine asses' milk. But I really sell you, I don't know, powdered chalk mixed with water, and you go away and bathe in that to your heart's content. And you come back to Septimus Maximus with a rash or whatever. It's not had the benefits for the complexion you thought you would. And you try and sue me, and I'm out of money. Can you sue the market operator? No, because there were various protections in place. But if the market operator had said, go to Septimus Maximus milk, that's the best milk in the world, had arranged the whole market to feature Septimus Maximus milk prominently, if you're following me, then
I didn't know we were going so far back in time. I'm loving it.
then I think the mere conduit, that I just provide the marketplace, changes because the marketplace operator is promoting a particular merchant and pushing people his way. So why am I going down that road? Well, I think that that's where we've got to with social media. And I've been, I think, a strong advocate historically for saying that those that merely provide the marketplace shouldn't have primary liability for the content or the offers in that marketplace. Of course, if they're put on notice, if they're told that somebody on their social media platform is doing unlawful things or illegal things and they do nothing about it, then of course they should be liable. But the ability of social media operators to read every single post was, of course, limited. But why I think I've rethought my position is because of the way in which algorithms are working on social media. There clearly are on some social media platforms, there's clearly a promotion by the owner of the platform or the operator of the platform to not treat all messages equal. So to give added prominence to some, maybe to align with political leanings, for example. And I think if the promoter is, or the operator of the platform is promoting some messages over others, I think it's legitimate to say that they're doing that because they stand behind that content. And so just as in my Roman world, the marketplace operator becomes almost a merchant himself, then it seems to me that we might want to re-examine the mere conduit for social media providers. And I'm not saying that we result in hard and fast rules, but maybe, the likes of Section 230 that you've talked about so eloquently in the past, maybe we need to revisit some of that and look at liability afresh in light of the way that some platforms are now behaving.
Well, I didn't think we were going back to Roman times. I thought we might, or even the Magna Carta. I thought maybe we'd get back as far as maybe our First Amendment in our Constitution in Section 230, but that was a great tour de force history lesson. Yes, there's a lot going on there. And may I respond, sir?
Yes, please do. Yeah.
Friend Roman. Well, sure. I mean, in the United States, there's this great belief that it's all about speech. We can speak at you as much as possible. It's embedded in our Constitution. Probably historically, we have a greater right to speech than even privacy. I think they're greater, as you know, greater privacy rights in Europe than in the United States historically. In 1996, of course, Section 230 of the Communications Decency Act was passed by our Congress, wanting these small, little, tiny, fledgling internet companies to have the ability to grow and flourish, and that would be good for our economy. And if internet service providers had to have responsibility for communications posted on their sites by third parties, by others, by their users, it would be such a great burden upon them, such that Section 230, the intent was to immunize from liability internet service providers for the posts of others. Now, when we talk about free speech rights, these are platforms that have terms of service, of course, and people just, agree to the terms of service without ever reading them. How many people actually read the terms of service? But the terms of service, the TOS, will explain what speech potentially is not allowed. And for example, speech that is hate speech that could potentially incite violence, that could be harmful to the general public, safety and health and welfare of the community. The internet service provider reserves the right to take down content that's put up within that context, or even to block people who promote such speech. And it even happened to our former president. But you make an interesting point because, and of course, there's a balance, because the more the social media company, for example, gets involved in terms of what we say calling balls and strikes, that I don't know if you follow American baseball, but to the extent they start becoming more of a referee and curating the content and saying yes, no, then they become more involved and potentially, arguably, I think what you're saying is they could have what's more traditionally known as publisher liability. If you're the New York Times and you're putting something up on your newspaper historically, you have some responsibility to make sure that it's factually accurate and certainly not false and potentially leading to great harm. And internet service providers wanted to avoid such potential liability, and Congress immunized that here again, so these tiny companies could grow. Well, guess what? They've grown very large indeed, and they're some of the biggest, most powerful companies in the world. So there is a balance there. And of course, you said TikTok. Many people literally get their quote unquote news from TikTok and other social media companies, Facebook, Instagram, and of course, it's not true investigative journalism. And so again, even without potentially inciting violence or seeking to assemble others to do so collectively, there's just the problem about false information. There was a lot of false information relating to the pandemic that could cause harm to people. So I'll stop there. I mean, I could keep going. We could teach a whole law school semester on this, but do you have any further thoughts to round this out, my colleague, my friend, my Roman, my countryman?
No, I mean, I suppose my only real thought is I think it's time for a re-examination. And I'm not saying that we move to primary liability for everything. I think that would be wrong as well. But I think we need to have a mature debate as a society now that the heat of battle, thankfully, has died down from the riots, cognizant of the fact that we've got what's likely to be a very heated election space in the US. Perhaps now is the time to sit down and have a period of mature reflection.
Yeah, it's a thorny issue because just even trying to come up with solutions, some people will agree on types of content and information they believe is accurate and true and should be available, and others will disagree. And at least in our country, we are deeply divided politically, and we're considered in some say a post-truth era, and one person's truth is not another person's truth, but sometimes we have true facts. 2 + 2 should equal 4. If we're going to start debate.
And you have apparently at least 3 nation states seeking to influence your election through use of social media.
That's correct. And some information now is actually being taken down on some sites as being known to be inaccurate. But there were some that argued that quite a lot of misinformation on the social media platforms had a role in our 2016 presidential election. So fascinating.
Yeah,
please.
I don't think we've got the answers, but at least maybe we've contributed a little bit to the debate. And that's probably about all we've got time for, isn't it, Eric?
We've identified the problem potentially.
Exactly.
And we had a history lesson to boot. Gratis.
Yeah. So I'm Jonathan.Armstrong at puntersouthall.law. Eric.
I'm Eric Sinrod at Duane Morris in the San Francisco office, ejsinrod at duanemorris.com.
And all that remains is to thank you for watching or listening. We'll hope to be back in touch with you in a few weeks with another topic. As ever, we've got a LinkedIn page where you can join the debate, or you can also suggest topics for future podcasts there as well. And thanks for watching.
Thank you very much. Bye-bye.